Is a verbal lease agreement legally binding? You shook hands with your landlord. You agreed on the rent. You moved in. No paperwork. No signatures. Now things have gone sideways, and you're wondering if that agreement was even real. Here's the thing. It might be more legally binding than you think. Welcome to Know the Law. Today we're breaking down one of the most misunderstood areas of landlord-tenant law, verbal lease agreements. By the end of this video, you'll know when a spoken agreement actually holds up in court, when it doesn't, and what protections you have either way. This is information that could save you from making a very expensive mistake. Let's start with the big surprise. Oral lease agreements for 1 year or less are legally binding and enforceable in most states across the country. That's not a loophole. That's not a gray area. That is the law working exactly as intended. If you and your landlord agreed verbally on a month-to-month rental, or even a 6-month arrangement, that agreement is real. It creates actual legal obligations on both sides. Your landlord has to hold up their end of the deal. So do you. Now, some states go even further than that. In most states, the 1-year rule is the standard. But under certain state laws, oral agreements can be enforceable for even longer terms. The point is, never assume a verbal agreement means no agreement. In most states, short-term verbal leases carry genuine legal weight. Here is where things get serious. Leases exceeding 1 year in length fall under something called the Statute of Frauds. That phrase sounds complicated, but the idea is simple. Certain agreements are too important to leave to memory and he said she said disputes. The law requires them to be in writing. So if you and your landlord verbally agreed to a 2-year lease, that agreement is generally not enforceable. It does not matter that you both meant it. It does not matter that you already moved in and paid rent for 3 months. Once that agreement crosses the 1-year threshold, the law in most states says it has to be documented in writing to hold up. Some people believe that if both parties act on a verbal agreement, if they actually follow through on it, then it becomes valid over time. That is not how it works. Under most state laws, a verbal lease for more than 1 year violates the Statute of Frauds and stays unenforceable, even if both sides have been honoring it. The length of the agreement is what matters, not the behavior of the parties. If someone is offering you a rental arrangement that goes beyond 1 year, get it in writing. Full stop. Now here is something that surprises a lot of people. Even if your verbal lease is unenforceable, or even if you just never signed anything at all, you still have legal protections as a tenant. These protections do not come from the lease. They come from the law itself. Landlords are required to maintain habitable conditions regardless of whether your agreement is verbal or written. That means heat, hot water, a structurally safe building. These are not extras your landlord gets to skip because there is no paperwork. Virtually all states recognize these obligations, and they apply to you whether you signed a 30-page lease or shook hands on a porch. Some tenants in verbal rental situations feel like they have no leverage, like they have no rights. That is simply not true. The format of your agreement does not strip away your basic protections as a renter. A landlord who ignores habitability standards is in violation of the law, no matter what kind of agreement you have. Let's talk about what happens when things go wrong. Some landlords assume that a verbal agreement makes it easier to remove a tenant. They think no written lease means no formal process. That is wrong. Even without a written lease, landlords must follow the law when it comes to eviction. If a tenant has caused property damage, the landlord must provide at least 72 hours notice to quit before moving forward. For other causes of eviction, the required notice is generally 720 hours. These are legal requirements. A landlord who skips this process and tries to remove a tenant by force, by changing locks, or by cutting utilities is exposing themselves to serious legal liability. The eviction process must be followed. it does not disappear because the lease was verbal. Also worth knowing, if you are in a month-to-month verbal arrangement and the landlord or tenant wants to end it, written notice is generally required under most state laws. You cannot just walk away or be pushed out without proper notice. Let's put this all together. Imagine someone moves into an apartment after a verbal agreement with their landlord. The term is month to month. No papers are signed. A few months later, the landlord stops fixing the heat. Then the landlord tells the tenant to be out by tomorrow. Here's what the law says. The verbal month-to-month agreement is enforceable. The landlord's failure to maintain heat is a violation of habitability law, regardless of the lease format. And demanding a tenant leave by tomorrow is almost certainly illegal. The proper notice of 720 hours is required for a non-damage related eviction. The tenant in this situation has real legal standing. And one more thing to keep in mind. If you ever need to bring a breach of contract claim related to a rental agreement, the statute of limitations varies by state but generally gives you several years to act. The clock is not short, but the sooner you act, the better. Now you know the law. Hit like, subscribe, and share this with someone who needs to hear it. And drop a comment below with the legal situation you want us to break down next. The law affects every part of your life, and you might as well know how it works. Knowledge is the one thing they cannot take from you. See you in the next episode of Know the Law.